Welcome to the debate. Today we are diving into, well, what's often seen as maybe the most obscure corner of the Bill of Rights, the Third Amendment. This is the one that prohibits the non consensual quartering of soldiers in private homes. Historically, it's, the least litigated amendment, sometimes dismissed as obsolete, you know, relevant only to those 18th century fears of redcoats.
And, well, arguably for good reason. Its text is remarkably clear, wouldn't you say? And specific. As Justice Story noted, it secures that common law idea that a man's house shall be his own castle, but crucially, against a very specific type of intrusion, the physical imposition of a standing army.
Exactly, but I think we can't just ignore its modern constitutional life. Remember Griswold v. Connecticut back in 1965? The Supreme Court explicitly pointed to the Third Amendment as part of that penumbra of rights, the ones that establish a fundamental zone of privacy, protected from government intrusion. So this really brings us to our central question today. Should the Third Amendment remain strictly limited to its, let's say, historical prohibition against physical billeting? Or does it need to be interpreted more expansively as a vital sort of evolving check on governmental and particularly military intrusion in our modern digital era, especially when we think about things like mass surveillance?
hmm And while I certainly acknowledge its foundational role in, helping establish that concept of privacy in Griswold, I still maintain that its clear, specific text really points towards a narrow, literal interpretation. When we start talking about digital intrusion and surveillance, well, frankly, we're pretty clearly entering the domain of the Fourth Amendment. That's the amendment that's really the primary constitutional standard bearer for searches and seizures of persons, places, and effects.
Okay, but I have to maybe push back hard on this idea that the Third Amendment is somehow obsolete. I actually see it as maybe the constitutional equivalent of a sleeper agent, waiting for that precise moment when the military machine gets a bit too close to the civil domain. My position is that the amendment's core principle, the idea that the military must be subject to civilian control and crucially, cannot functionally invade private life, is highly relevant today. It was written, I believe, to erect a barrier against an overly intrusive and regulatory government. And if we're going to honor that historical purpose, we must apply it expansively to address modern, pervasive digital surveillance.
A sleeper agent? Perhaps, but one that's been sleeping pretty soundly since 1791. Look, the historical context here is, I think, undeniable. It's specifically tied to the fear of a visible, tyrannical standing army and the abuses, of course, of the British Quartering Acts of 1765 and 1774. The harm was concrete, forcing a homeowner to physically house and provision troops with necessities like, bedding, candles, beer. The text says, quite plainly, no soldier shall be quartered in any house. That clarity, I think, is its strength, not a weakness.
But constitutional interpretation almost always demands some flexibility, doesn't it? We already know the Third Amendment helps establish these zones of privacy, and importantly, lower courts have shown this flexibility. Just look at Engblom v. Carey back in '82. The Second Circuit expanded the protections in two really crucial ways. They included state National Guardsmen in the definition of soldiers, and they protected tenants, not just fee simple owners, anyone who had a legal expectation of privacy. That decision, I think, proves the amendment isn't just some archaic historical artifact. Its actual purpose seems to be the enjoyment of a private tenancy without governmental incursion. And that purpose, well, it's fundamentally undermined by mass functional intrusion, even if it's not physical.
I see Engblom a bit differently. I mean, yes, it was an adaptation, but I'd argue it was a necessary adaptation specifically for tenancy rights when dealing with state-controlled militias who were, acting in a quasi-military capacity during a strike. That feels like a defensible, fairly limited expansion, still within the sort of physical scope of the original text. But stretching the literal language, soldier, quartered, any house, to cover remote, complex digital issues, that risks making this very specific prohibition kind of redundant. The framers intentionally created the Fourth Amendment, didn't they, to deal with broader searches and seizures? If we expand the Third Amendment too far, we start to diminish its precise historical check on the physical overlap of military and civil authority.
Right. And that brings us directly to this question of the functional definition of these terms in the digital age. If the constitutional principle is really about limiting military intrusion into civil affairs, then we have to ask, what does a soldier do today? And what does it actually mean to be quartered? My argument is that soldier has to evolve. It must include potentially cyber agents or military personnel who are utilizing these modern surveillance instrumentalities. Think about it. When the Constitution was written, the instrumentalities of the soldier, their weapons, their supplies, and most relevantly perhaps, their horses, they also required space, right? They created a physical imposition on the owner.
That's an interesting analogy, the one about instrumentalities. I grant you that, but I'm still skeptical of that broader reading for quartering itself. The historical meaning, again, was physical billeting. It required providing board or lodging, a functional intrusion. Even if it's deeply invasive, it's already pretty extensively addressed by Fourth Amendment jurisprudence, isn't it? Particularly the whole requirement for a reasonable expectation of privacy. The kind of concerns you're raising where, hyperlocal, cumulative observations create this intimate picture of a person over time. That sounds exactly like the mosaic theory that Justice Sotomayor discussed in our concurrence in United States v. Jones.
Yes, I know the Fourth Amendment covers the mosaic theory, but we're talking about something that could be seen as a functional equivalent to physical presence, originating from a military source. Imagine pervasive drones, which are often military instrumentalities, capturing images through windows, or maybe hovering over a home's curtilage. Or think about actual state-sponsored cyber warfare systems. You mentioned Stuxnet earlier. That was a highly sophisticated piece of malware developed, we believe, by military or intelligence agencies to target civil infrastructure. Now, when similar tools are used by, let's call them cyber agents, to infiltrate and functionally occupy a private network, which is now essential to the modern home, how is that not the 21st century equivalent of physical billeting? It diminishes civil life just as profoundly, I'd argue.
I appreciate the need to, contextualize for modern technology. But the distinction between, say, a state-sponsored cyber weapon targeting international infrastructure and the specific constitutional wrong that the Third Amendment addresses, a uniformed soldier demanding a bed and beer, that distinction feels massive to me. The Fourth Amendment is flexible enough to define a search based on technology. Look at Kylo v. United States. The court said using a thermal imager on a private home without a warrant was a search because it provided intimate details about life inside. We have established ways to deal with technology under the Fourth. We don't need to stretch soldier, which again is a bright line term chosen specifically because of that historical fear of a standing army, to mean, any government agent running a data script.
But that bright line, that separation of military and civil power, is exactly what the Third Amendment protects. And maybe this moves us to the scope of protected property. Even if we could agree on a potential modern definition of a soldier, that only matters if the amendment still protects the space where the intrusion occurs. You mentioned the strict limits of any house.
Yes. Any house does seem, highly restrictive on its face, focused squarely on the private residential dwelling.
But again, look at Engblom v. Carey. It rightly extended owner to include a tenant who had a legal expectation of privacy. That recognizes, I think, that the protection is about the sensitive civil life that happens within a private space, not merely about who holds the deed, the fee simple ownership. So if sensitive civil life now also occurs in businesses, think about private intellectual property, confidential meetings, personal digital records stored on company servers. And if the military apparatus intrudes on those businesses, or maybe the curtilage around a home using surveillance tech like, what was it called? BOSS, the Biometric Optical Surveillance System, which is high-powered stuff for intimate real-time tracking, well then, shouldn't the amendment's protection extend beyond just the four walls of a residential dwelling to protect that civil life wherever it happens?
I remain highly skeptical
of that kind of expansion, extending any house to include business properties. It seems to fundamentally change the amendment into a sort of general anti-intrusion clause. And if you do that, you really merge its purpose entirely with the Fourth Amendment, which already protects all places and effects. The framers chose the specific narrow term house for a reason, to address a very unique historical fear. If we expanded to cover all private chattel or business property or electronic devices, we risk making the Third Amendment completely redundant. I mean, why have a specific rule against quartering soldiers in houses if a general rule against unreasonable searches already covers it, and maybe covers it better?
Because, and I think this is the key distinction, the Third Amendment is unique in its focus. The restriction on military intrusion into civilian affairs. The Fourth Amendment, well, it primarily focuses on policing actions, warrants based on probable cause, largely carried out by civil authority. The Third Amendment provides this vital, targeted check against governmental overreach, specifically when the military or military intelligence apparatus gets entangled with civil functions. Its purpose, fundamentally, is to maintain rule by civil authority, not by military force.
That's a valid structural concern. I absolutely grant that. The separation of military and civil is important. But is the Third Amendment the right tool, or is it too blunt an instrument, perhaps, to fix that potentially broken process? Today's mass surveillance, as you know, it's generally covert, it's conducted by interagency teams, often described with terms like cyber sleuths, not by uniformed soldiers knocking on doors asking for lodging. The military-civil overlap you fear is real, but it's often deliberately obscured. It's frankly hard to imagine successfully arguing in court that, say, an intelligence analyst looking at metadata provided by a third-party tech company is somehow a soldier engaged in quartering under the Third Amendment. The text uses that bright-line term, soldier, and trying to shoehorn complex, opaque interagency surveillance into that very narrow text, it risks, I think, conceptual inconsistency.
But the opacity you mention is the problem, isn't it? When the government obtains sensitive data through, let's say, proxies, for instance, swapping data on citizens with foreign intelligence partners, or maybe utilizing specialized military hardware like drones on U.S. soil, that military-civil overlap becomes very real. Even if it's remote or hidden, the intrusion is functional. It's targeted at civil life, and it's performed by agents, or at least using instrumentalities that serve a military or quasi-military function. The historical prohibition was intended to avoid the confluence of military and civil authority, and mass surveillance today arguably represents that confluence in its most opaque and perhaps most intimate form.
That is certainly a complex modern problem, no doubt. And complexity usually requires looking at it from multiple angles to really grasp it. But the structure of the Bill of Rights, it seems to me, gave us a very specific, clear prohibition in the Third Amendment, designed for a physical, visible threat from the past. And it also gave us a more general, adaptable prohibition against unreasonable searches in the Fourth Amendment, which seems designed precisely to handle these kinds of ever-evolving modes of intrusion. So in summary, my view is that the Third Amendment remains essential, but as a safeguard against the specific historical grievance of military billeting. Its real strength lies in its clarity and specificity. It prevents the government from forcing physical quartering, whether by federal troops or, as Engblom showed, by incorporated state National Guardsmen. I think caution is really essential when we talk about expanding its terms. Overbroad interpretation risks diminishing its specific targeted purpose and risks duplicating the more appropriate and frankly more flexible domain of the Fourth Amendment when it comes to digital privacy issues.
And I would conclude that the Third Amendment's core purpose, to limit the presence and, importantly, the instrumentalities of the military within the civil domain, is actually profoundly relevant today, precisely because military and cyber capabilities are becoming so deeply intermeshed with civil life. To really honor its recognized contribution to that zone of privacy established back in Griswold, concepts like soldier and quartering simply must be interpreted contextually, functionally, maybe even expansively, to meet the challenge posed by the functional intrusion of cyber agents into what is now the modern digital equivalent of the private house. This whole debate, I think, really illustrates the ongoing intellectual challenge we face in applying these vital 18th century rights to our 21st century technology.